It's in the plain language. Let me start over. So in other words, in order to be a principal, Ms. Adelson had to have a conscious intent that the criminal act be done, and that she did some act or said something intended to and did incite, cause, encourage, assist, or advise the other person to commit the crime. Sorry. Removing the intent to commit murder, we believe, in the proposed instructions runs counter to that. So specifically,
well, as it relates to the intent to commit the crime, but there does not have to be an intent that a death occurred with either second-degree murder or manslaughter.
I think the way it's written, Your Honor, is confusing. That's my concern with the jury.
Mr. Evans, Ms. Capeland.
Your Honor, I don't believe that it is. Second-degree murder, it's, I think, because this is from standard instructions, as I recall.
This is.
And so I think it's sufficiently covered because it is not saying that the state doesn't have to prove that the person intended the act. It's simply not necessary the state prove that they intended the death to result from the act. And so I don't think anybody's going to be arguing that. I think the instruction is clear, the standard is clear on it.
I think specifically as to that portion of the standard, Mr. Zellman, that does crystallize the issue. The state must argue there was intent that the crime be committed, but as far as there being an intent that the victim of the crime actually died, that is not required by second-degree murder as a standalone crime or as a principal matter. The same would apply to manslaughter as well. As to any objection that you wish to raise, I'll allow you to make it now.
Just a moment, Your Honor. Ms. Fulfer is explaining what I'm about to make, what I'm about to request to make sure that our client agrees with that. Your Honor, given the court's ruling on that, we would ask that second degree and manslaughter not be given.
On what basis?
Your Honor, look at the charging document briefly. As I indicated previously, Your Honor, it's our position that the two sentences at the end of the principal instruction, specifically for second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. As I indicated, it's a question of intent, and the principal instruction, the main portion, defendant intended the crime to occur. I just think it's confusing. I understand the state's position, but under the circumstances, we would request that the court not give those two lessers.
Moment.
As I understand it, they're requesting just for count one simply to be guilty of first-degree murder or not guilty.
No, Mr. Evans, to omit the lines pertaining to second-degree murder and manslaughter in the 3.5 sub A instruction.
Mr. Evans' understanding of our request is accurate. We're asking that the two lessers for count one not be given, and that would eliminate the necessity for those two sentences in the principal instruction.
What is the state's position?
They're talking at the moment, Judge.
Uh-huh.
We're fine with doing away with the lessers on count one.
On this matter, I will need to take a call clear from defendant. Ms. Adelson, please rise, raise your right hand this morning. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, Your Honor.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first-degree murder?
Yes, that's correct, Your Honor.
In consulting with your attorneys, you understand the strategy of waiving all lesser included crimes.
I do, Your Honor.
Is there anything that you need to consult with them further about concerning this matter?
No, there is.
Then you may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
Given that, Your Honor, I believe moving the two principal instructions directly after count one would also be appropriate.
Removing the reference to second-degree murder and manslaughter and principal instruction as well.
You get through that, Judge, I did have one side, I to change that thing, that I'd like you to consider. On principal instructions, the last line.
Give me one moment.
Judge, before moving the two principal instructions after count one, Mr. Evans raised a good point.
Give me one moment. All right, concerning the